Hi everyone, hope you guys are studying well. So today we will be starting with the revision of prospectus. Prospectus is basically nothing but a document which you issue when you want to invite money from the public. If you are a public company, you can issue prospectus and you can invite money from the public by way of IPO or for the public offer. And if you are a private company, you can do only bonus shares, right shares and private placement. A public company can do all four. It can do public issue of shares, private placement, bonus shares and right shares. So if you are a public company, you will be required to issue a prospectus. Now coming to what are the different kinds of prospectus that we have. We have the shelf prospectus, the red herring prospectus and the abridged prospectus. Shelf prospectus is nothing but when you want to issue the same kind of security during the year, you issue a prospectus which is kept on the shelf and you use it so that you don't have to do the entire compliance. You save time and cost in doing the entire compliance, and hence you have this shelf prospectus. So it is only when you are issuing the same kind of security in a period of 1 year that you have your shelf prospectus. Now when the second time I am issuing the securities, my some of the details may change. It may not be exactly same as that is there in the shelf prospectus. So what do I need for that? I need an information memorandum. So when first time I file the shelf prospectus, second time when I am issuing the same security, if there are any changes, I will file the shelf prospectus along with the information memorandum, and those two documents together will constitute my prospectus. Second is red herring prospectus. Due to the change in the different way in which you can raise funds, you have your red herring prospectus. What is a red herring prospectus? It's a prospectus where the quantum or the price of the security is not mentioned in advance, and once you raise the money from the public, depending on how much money you've raised and how much capital you want to issue, you will put down the quantum or the price. So it is a fully made prospectus like any other prospectus. It has all the details that a prospectus is required to have, but it will not have the quantum or price. That is put on at a later stage in time. Third is your abridged prospectus. What is a abridged prospectus? It is nothing but a summary, a short prospectus which is relevant for the investors to know what is there in the prospectus. Only that information is put in the abridged prospectus, so that when the investors are investing, they don't need to go through that long 400-500 page document, and they can just go through the summary of the prospectus, things that they need to know. What is the object of raising the fund, how much funds are we raising, where are we going to use it, all of those things. So that will form part of your abridged prospectus. Now what are the things that are required to be there in the prospectus? This is something this has been asked in your examination as well. Prospectus definition, again this time, because in May 22 examination the MTP RTP they have incorporated a lot of definitions, and hence it is very important that you go through the definitions. Prospectus is covered under section 270. It includes a shelf prospectus, a red herring prospectus, and any other notice, circular, or whatever name, advertisement, whatever name you call, where you are inviting money from the public, will be covered under the definition of shelf prospectus, under the definition of prospectus. Now what are the matters to be stated in the prospectus? Now all these matters are coming from section 21, but that is something which we don't have to write it in very detail. But the important things that we have to write here is that the prospectus has to be dated, signed. It will include all the financial information that is required to be incorporated as per section 26(1), and it will have an export statement. Export statement is by an independent party who has given his consent and who has not withdrawn his consent at the time of signing the prospectus. So export statement is something which is required along with the prospectus. Other than that, you need information under section 26(1) and the reports which are required to file. Consent of the export is essential, and then the same has to be signed by the directors, and a copy of the same is to be delivered to the ROC along with the requisite documents. Now once you have to submit this with the ROC, once you have submitted it with the ROC, you will submit it before you issue the prospectus to the general public at large. So first you give it to ROC, then you have to issue. Within how many days do you have to issue the prospectus? You have to issue the prospectus within a period of 90 days from the date you have given the document to the registrar. Okay. So this is about what are the different kinds of prospectus and what is a prospectus and what are the things that are to be incorporated in the prospectus. Now coming to dematerialization of securities. So what is dematerialization? One is you keep physical securities wherein you have the actual share certificates, which is still allowed, which a private company can do. Dematerialization is you have it in demat form, in a format where the depositories are maintaining a record under the Depository Act, and every public company is required to have securities in the demat form only. So earlier it was only listed companies which were required to have in demat form. So whenever they are trading in securities, they will have the securities in the demat form. But now for unlisted public companies from 2nd October 18, if they want to transfer any security or they want to deal with any security, then that has to be in the demat form only. So it has to be put in the demat form first, and only then they can trade in that particular security. So every public company is required to have securities in the demat form. Private companies can have securities in physical form also, and that is perfectly okay. Demat form securities are regulated by the depository. So depository is the person who will keep a record of all the securities that are in the demat form. And as a company, it is my responsibility and to ensure that I have paid the necessary fees, I have filed the necessary documentation with the depository who is maintaining my record, and that is the responsibility of the company whose shares are with the depository. Then coming to what is a deemed prospectus. Deemed prospectus क्या होता है? That the prospectus, the normal prospectus is something which we issue and I want to raise money from the public. But sometimes people want to act smart. So what they used to do is that they will issue the shares to the private company, and the private company will then in turn give the shares to the public at large, because it's a public company share and the public company shares are freely transferable. So that what will they achieve by doing that? They will achieve the thing that they will not have to do all the compliances which a company is required to do for raising money from the public. It's a lot of compliance. Making the prospectus itself would take like 3 to 5 days, 5 months. So it's difficult, it's time consuming, and hence a easier way is to do a private placement to a company, because a public company can do private placement, and that private company company who's done the private placement, that company will sell the shares to the public at large. So now in this way you're giving the shares to the public at large without actually doing all the mehnat of prospectus. So there are two conditions which you have to take into consideration. First is, has the allottee sold the shares to the public within 6 months? So once I have given you the shares, I have done a private placement, if I have given you the shares, if you have sold these shares to the public at large within a period of 6 months, it will be considered to be a deemed prospectus. If you have not sold it to the public at large, you have kept it to yourself, but you have actually not paid the money. So what happens is, this is the company, the public company, it's given shares to by way of private placement to ABC and company. Okay, and this ABC and company, the only purpose why it is going to give you the share taking shares from you is it wants to give it out to the public at large. Now what is happening here is that ABC and company doesn't really have the money that you require to raise from the public. So what will it do is that it will hold the security for 6 months, it will not pay you for those securities, and then once it sells it to the public after 6 months, it will collect all the money from the public and then give the money to you. So the second criteria is, has the allottee paid full consideration to the company before offer for sale to the public? If it has not paid, then it is clearly a case of deemed prospectus, because you will collect from the public and then pay. If you have paid and if you have held the security for 6 months, you are free to sell it to the public at large, and it will not be considered to be a deemed prospectus. This is a very, very important concept which will be asked in your practical case study type of questions. So deemed prospectus is something very important. Other than that, any advertisement, any other form by which you are giving out the shares to the public at large will be considered to be a prospectus as per your section 270. Now, if it is a deemed prospectus, what all things are you required to do? You have to have a document, it has to be signed by 2 directors. All the provisions pertaining to prospectus shall apply. So now you will have to have like a proper prospectus and do all the documentation of expert report, all of that you will have to do now. And additional disclosure to be made for the net amount of consideration received or to be received, time and place at which contract of said security has been made, and the allotment to be inspected. Now coming to offer for sale. of shares by certain members. What happens is that sometimes the members of the company may have securities and they may want to sell it out to the public at large. So here, if you are selling anything to the public at large, that will be covered under the definition of prospectus, because if you are giving something to the public at large, it is prospectus by whatever name you call. So when the members are also giving it, that is again something which will be called as a prospectus, and they will have to do all the compliances. The company will do all the compliances which are required to be done because you are issuing a prospectus. But there are certain compliances like minimum subscription, underwriting commission, all of that will not apply because they are just selling their shares to the public. They are not like raising funds. When you are raising funds, you need minimum subscription, underwriting commission, all of that. Here they are just selling their part of the shares to the public, so they have to comply with the prospectus provisions, but not all the provisions of the prospectus. Now, company will do all the mehnat on their behalf and take the shares from them, give it to the public at large, and all the cost of the same will be borne by the members because the members are selling their shares. So whatever the cost is incurred in giving the shares to the public, in issuing the prospectus by whatever name you are calling it, and doing the compliances as required under the act, the cost will be borne by the member who are actually selling their shares. So it is a prospectus, but not all provisions of prospectus will apply, and the members will have to bear the cost of selling the shares. Okay. Now coming to a very important concept, variation in terms of contract or objects in prospectus. Again, something that we did in the last chapter pertaining to objects. What is it saying? That if I have raised money, say I have raised 500 crores from the public at large for making the COVID vaccine, but then I realized that there are two companies who have already got the COVID vaccine in picture. So they already have it, people have already taken the dose and they are now taking booster dose and everything is already done. So I've used 250 crores out of it, say 300 crores for ease of understanding. 300 crores I've already used on the research and trials and all of that. I have 200 crores pending, and I feel that, you know what, I don't really need to spend 200 crores on this. Instead, I would have, better to have like a hand sanitizer plant, jahan pe I'll make hand sanitizers, because that is something which is the need of the hour. So now it wants to change the objects of the company. Now, if you raise money from the public at large, they have given you the money based on the prospectus which said that you're going to develop a vaccine. They may not necessarily be interested if you're changing from developing the vaccine to developing hand sanitizer, and they may not want to go ahead with it. So if you're changing the objects for which you have raised money from the public at large, first thing you need is a special resolution. You need to take approval from the shareholders, 75% approval, and you have to tell them that how much money you have taken, how much money you've used, why you are changing, what is the new business you are going into, what are the risk factors involved if you go into that particular business, all of those details, and you have to take an approval. But of course, there are not going to be all shareholders who are going to agree to that. So if the shareholders agree to that variation, and if they are saying that, okay, we also believe that, hand sanitizers is the next big thing, and they want to go ahead with that, then they can go ahead. But if they decide that they don't want to go ahead and they feel, no, this is a very shitty idea, we don't want to go ahead with this, then in that case they will be called as the dissenting shareholders, and these dissenting shareholders will be given an option to exit at a price which will be determined by a third party valuer based on the SEBI regulations. So they will be given an option to take back their money and no longer be a shareholder. People who agree to the variation can go ahead and keep the shares in the company. Now, coming to securities to be dealt with on a stock exchange, if you want to raise money from the public at large, the only way you can do it is through the stock exchange. And if you want to do it through the stock exchange, you have to take the approval of the stock exchange. A very important point that has to be noted here is that you will have to apply to the stock exchange, and the approval will be given by the stock exchange based on which you will make the investment. Now, say for example, if I have applied to 3 stock exchanges, out of which 2 have approved and 1 has rejected, can I go ahead with these 2 stock exchanges and issue the securities to public at large? You cannot issue the securities to the public at large even if 1 stock exchange doesn't give you the permission. So always remember, this can be asked as a practical case study type of question, that if you have applied to the stock exchanges and if they have given you the approval, all of them, then you can go ahead. But even if one of them has said no, you cannot issue the shares to the public at large. So you need the approval of all the stock exchanges to whom you have applied to, and only then and then you can issue the securities. That is some important point to note here. Now when you're doing money, you're raising the money from the public at large, you will also pay underwriting commission. How much of the underwriting commission has to be paid is, if it's a share, then 5%, or the amount which is given by the article, whichever is less. If it's a debenture, it's 2.5%, or the amount given by the article, whichever is less. How much money is required to be raised? You need to have at least application money of 5% or more, as may be specified. Once you get the money, if you've received all the money, then within 60 days you have to allot the shares. So once you get the money, within 60 days, it's not written here, within 60 days you have to allot the shares. If you do not allot the shares, then you will have to refund the money to the general public at large from whom you have taken the money, and that refund has to be done within a period of 15 days. If you do not refund it within a period of 15 days, then of course there will be an interest that you have to pay at around 12% per annum. But also, if that money is not refunded, then if you go to your deposit chapter, it will be considered to be a deposit. Remember, if you have taken share application money, you have to allot securities within a period of 60 days. If you don't do that, you get 15 days period to refund the shares, refund the money, and if you don't refund it within a period of 15 days, you have to pay interest at 12% per annum. But also that amount that you have taken will be considered to be a deposit, and you will have to comply with all the regulations of deposit that's required under the Deposits Act. Correct? Now, coming to misstatement in prospectus, if you have mentioned something which is incorrect, here there are two possibilities. One is a civil wrong, the other is criminal wrong. Civil wrong is something that is there by mistake, or something which was neglected, or you couldn't put it. And criminal is something wherein mens rea is present, a guilty mind is present. So if you put something where guilty mind is present, then 447 will be there, and if mens rea is not present, then it will fall under civil liability. And then every company director, proposed director, promoter, expert who has authorized it will be penalized. In case of criminal, every person who has authorized the prospectus will be penalized under section 447. They have their defenses that they can claim. In case of civil liability, they can claim that they believe that statement was true when they gave the consent, or they had already withdrawn their consent, or it was issued without their knowledge, and that are the defenses that they can claim in the court of law. In case of criminal liability, they can say that though it was there, it is something which is immaterial, it doesn't impact the investor's decision as to whether he wants to go ahead with the investment or not, or you had reasonable grounds to believe at that point of time that whatever was mentioned is correctly mentioned. If you state that, then that is a defense that is available to you, and the court may consider your defense. Now, if you are fraudulently inducing any person to invest money in your company, again 447 will be invoked. Now coming to action by affected person, just let me see if we finished everything else. Yes, action by affected person is something which is Gift of Companies Act. If you remember, we had discussed that during the Satyam case, because a lot of investors were stranded, their money was taken, and they couldn't take action because the cost involved was higher, and they couldn't take like a group action. The Companies Act 2013 decided to have a section for class action, where if an entire group of people is affected by something that a company has done, and if they collectively want to take an action for the same loss or damage that they are suffering, then they can do so under section 37. Now, punishment for fraud under 447, again something which we should be remembering before we go for the examination, because that is something which we mention again and again at many places wherever mens rea is present. Now coming to private placement. Private placement is something where I identify individuals whom I want to give the shares of the company, and once I have identified these individuals, I will give the shares to them. So this is not to the public at large, this is to private individuals. It's like a party, correct? I told, if you go to the pub and if anyone and everyone can come to the pub, then that is called as a public issue, because public issue, anyone and everyone can pay and take the shares of the company. But private placement is like a house party where only people you have called can come and not everyone else. So a private placement is where you are giving shares to specified number of individuals. A private company can raise money by way of private placement. Public company can also raise money by way of private placement. How many members do you have to issue the shares to? You can issue the shares to not more than 200 members, and that is 200 is for each kind of security. So equity shares 200, preference shares 200. It is for each kind of security. And while calculating the 200 limit, you will also exclude your qualified institutional buyers, and you will also exclude the employees who are given stock shares under the employee stock option scheme. So these people are someone who will be excluded. Now, if your number of people exceed the number of people, so if you exceed 200 ka limit after taking all the exclusions and everything into consideration, then it will be considered to be a deemed public offer. If you don't exceed, then it will be considered to be a private placement. In private placement, again the same provisions will apply, that once you have received the money, then within 60 days you will have to make the allotment of shares. If you do not allot it within a period of 60 days, then you will have to refund the amount. If you do not refund, then it will be considered as deposit, and you will have to pay interest at the rate of 12% per annum. Yes. So that is all about your, and of course there is penalty for non-compliance. If there is any non-compliance, then you will have to pay penalty. Private placement के लिए one more important thing is that you need to pass a special resolution, and special resolution के साथ साथ you will need a explanatory statement under section 102, because it is not ordinary business that you are transacting, it's a special business that you are transacting, and hence you need an explanatory statement giving details about how much money you are planning to raise, how you are planning to raise, how is it valued, who is the third party valuer who is valuing the securities, what is the price that has been arrived at, how are you going to use the money. All of those details will be given in the explanatory statement, which will be attached with the notice which you will send out for passing the resolution at the meeting. So this is all about your prospectus, public and private issue of securities, and I hope this was helpful.